Assalamualaikum and greeting to all. We group of 10 from the subject of Real Estate Law 2 would like to present our latest assignment regarding issues related to sale and purchase agreements in Malaysia, which was presented by me, Muaz bin Abdul Fattah, and my group members consisting of Nur Nabila Husna binti Irwan, Emiliana binti Abdullah Hussein, Siti Norzurina binti Zainabidin, Nurmah binti Saluhi, and Nur Afikah binti Ija. Please enjoy our presentation.
Okay, next I will present my part, which is abstract. In legal terms, sales and purchases refer to the transfer of ownership and title of goods of property from one party to another party in exchange for some form of consideration, typically money. Various legal principles and rules govern this transaction, which vary based on the jurisdiction and the nature of the goods or property involved. This chapter deals with the sale of land, a building, or a parcel in a subdivided building or land parcel in Malaysia. There are several approaches taken. The purpose of this writing is to introduce such transaction to the general reader and to only elaborate on the silent features, issues that might be developing, and how is the system in Malaysia of dealing with sales and purchases. The discussion begins with explanation of the features of land ownership and the law governing and purchases transaction. It highlights that Malaysia applies the torrent system of title by registration and describes the contractual and statutory dimension in which the sale and purchase of the land operate. There are several issues that arise from buying and selling land. In this title, issues arise from land as the subject of buying and selling. Issues related to these matters are to be considered and signed by any authority to ensure the success of the transaction. Among the issues that may develop is the date of the parties pending registration. Secondly is the effect of oral agreement. Thirdly is booking pro forma. Next, sales by administration. And lastly is deposit. Statute, common law principles, and specific regulation mainly establish the legal framework governing buying and selling transactions in Malaysia. Buying and selling goods and real estate in Malaysia is subject to various laws and regulations, and the process can vary depending on the type of transaction. For example, the National Land Code, for transactions involving the sale and purchase of land and real estate, the National Land Code is an important piece of legislation. It regulates an ownership, transfer, and dealing with land in Peninsula Malaysia. In addition, the Contract Act 1950 discusses the basic legislation in Malaysia that governs contracts, including sales contract. It sets out the requirement for the information and validity of the contract, the term and condition, and the consequences of breach. Finally, is the Stamp Duty Act of 1949. The Stamp Duty Act imposed stamp duty on certain documents, including those related to the transfer or property. The Stamp Duty Act of 1949 regulated the imposition of stamp duty on various instruments used in real estate transactions. I pass this presentation to the next presenter.
For introduction, sale and purchase. A sale and purchase agreement is a legal document that defines the roles and responsibilities of parties involved in real estate transactions. It identifies the buyer and seller, provides a clear description of the property, and defines the purchase price or mutual purchase price. The contractor also includes payment terms such as initial, deposit, installments, and final payment. Next, the torrent system. The torrent system, Malaysia land law, is the use for land registration, allowing registered owner to gain permanent ownership of property. The sale and purchase of land in Malaysia is subject to both statute law and contract law. The Malaysian expropriation process involves a sequential process that require mutual consent from both parties. A contract is concluded when the seller agrees to sell the lot. The buyer agrees to the term specified in contract, and a deposit is paid as part of the purchase price. Two main documents are formalized as part of the transfer process: the purchase and sale agreement (SPA) and the transfer agreement (MOT). Next, the SPA is governed by the Contracts Act of 1950 until the agreement is concluded. The sale is considered concluded after registration of the transfer in the land office. The ownership is transferred to the buyer names. In Malaysia, the law governing the sale and purchase of land are mainly the Contract Act 1950 and the National Land Code 1965 (NLC).
I will continue with my part, which is common issue in sale and purchase agreement. There are 5 common issues. Firstly, dates of the parties pending registration. In the sale and purchase agreement, even if one of the parties to the contract die, the deal in the contract can still be carried out, but must follow the condition. The contract must be complete according to the original contract period to avoid any negative impact. This issue related to case law Haji Osman versus Said Noor. Secondly is booking pro forma. A pro forma booking form is a piece of paper that lists the main part of the sale and purchase agreement, including names of the people involved, a description of the property, and the price. Both parties will sign it before it's official. Section 2B of the Contract Law 1950 provides that the person who accepts the offer must sign it to show that they agree to the term of the contract. If this is not done, any breach of the original contract that wasn't signed can be covered by the law because the agreement is subject to the contract. This issue is related to case law Qaid versus Mohammed is. Next is deposit. Deposit is a down payment for the purchase of an item or property. Usually, the buyer must pay 10% of the actual price. There is issue with the deposit when the buyer cannot pay the full amount of the property which price within the time frame listed in the contract. The buyer loses the deposit because the seller currently owns it. This issue related to case law Lingi Plantation. The next issue is the effect of oral agreement. In legal context, the enforceability of oral agreements can be a complex issue, and it varies based on jurisdiction and the nature of the agreement. Oral agreements are usually valid and legally binding. This is issue and difficulties that come with them. The statute of frauds is one of them. The statute of fraud requires certain type of contracts to be in writing to be valid in many places. The statute of frauds usually applies to real estate, marriage, goods of a certain value, and contracts that cannot be carried out within a year. It's possible that an oral deal that is covered by the statute of fraud and not in writing may not be enforceable. One common example of the statute of frauds impacting the enforceability of an oral agreement is in the context of the sale of real property. Buying or selling land or real estate contract often need to be in writing to be legally binding. This issue related to case law Diamond Peak Senior Berhad versus Tweedy.
Next, the analysis of the issues. First and foremost, in 2010, Haji Osman, a landlord of a small estate land, entered a land sale contract with buyer Said Noor. However, before the 14A form could be registered, Osman died. The National Land Code 1965 Section 292 states that if the landlord completed the transfer of the ownership form, his death does not affect the contract's validity. The buyer can apply or make a petition for the division of inheritance under the Small Estate Act, and the land administrator will consider this matter under Section 13 of the Small Inheritance Act 1955. The court held that the contract is not fulfilled when the land's registered owner dies before the transfer is finished, and a trustee for the deceased buyer has the right to proceed with the transaction. Next, in Diamond Peak Sendirian Berhad v. Dr. Tweedy, the defendant argued that a binding contract was not formed until technical details were incorporated into a written agreement. However, the Contract Act 1950 states that an oral contract for an immovable property sale is valid and enforceable. Thus, the court also noted that the English Statute of Fraud applies to contract for land sale in West Malaysia, even if not written. In this case, the defendant must understand that the sales and purchase agreement between both parties is valid.
Next, I want to share about analysis 3. Analysis 3 is about the booking pro forma. The case of law carried versus Muhammad Isa 1963 MLF 165 regarding the issue of the booking pro forma. In the case of law carried versus Muhammad Isa 1963 is the acceptance rule. The contract only can be said to be concluded when there is an acceptance made to the offer. The most important element in a contract is the absence of acceptance will result in the contract to become invalid. Section 7A of the Contract Act 1950 explained that for a proposal to be converted into a promise, the acceptance of the proposal must be absolute and unqualified. It is considered as an incomplete contract and cannot be enforced by any party. The plaintiff in this case needs to understand how options work before deciding whether to fight and win in the court.
This section provides a comprehensive understanding of the case Haji Saud v. Haji Ahmad and Anor and its implications on the administrator's discretion in agreeing to the sale of land. It correctly emphasized the significance of the term may in legal context and indicating the presumability or discretion rather than a mandatory requirement. Is that the nuanced nature of this discretion, emphasizing that the specific circumstances or conditions outlined in the law and regulations may govern the exercise of this discretion. The case in question underscores the need for prior court permission for the actual transfer of land and registration of the purchaser, even though the administrator have the discretion to agree to the sale. In essence, it effectively captures the key elements of the case and clarifies the balance between the administrator discretion and the legal procedure that must be followed to ensure a valid and lawful sale transaction.
Next, I want to share about Analysis 5. Analysis 5 is about deposit. The case of Lingi Plantation case, the court held no difference between deposit and earnest money. In the case of Lingi Plantation, the court had that no difference between deposit and earnest money. The appellant was the vendor of an estate. It sold the land at the price of $3,775 to the respondent by a contract of sale that on 25 May 1962. The contract provided for initial payment of $3,077,500. The vendor gave notice on 27 August 1962 that the contract was at the end and purported to forfeit the deposit under the above clause. The purchaser sued for the return of deposit. In summary, for this case of breach of contract, the vendor has the right to forfeit the deposit and to claim for any damages suffered over and above the amount of the deposit without having to prove the damage they have suffered. I think that's all from me. I pass this presentation to next presenter.
Jump into conclusion through the whole discussion on the issue provide a comprehensive overview of the legal framework governing real estate transaction in Malaysia, with a focus on issue, regulation and case law related to sales and purchase agreement.
It discussed various aspects such as the impact of the third party involved in transaction, the validity and implication of oral agreement, ambiguities in pro forma booking, sales by administrators, and the handling of deposit in property transaction. The case delved into the importance of clear and the legal requirement for the real estate transaction, emphasizing the need for specific legal procedure to ensure the validity and legality of sales and purchase agreement in Malaysia. In summary, this writing provides a detailed analysis of the legal principle, challenges, and regulation governing real estate transaction in Malaysia, offering insight into the complexity and legal consideration involved in sales and purchase agreement. That's all for our group. Thank you.